Good morning. Thank you all for joining us today as we discuss navigating the recent impacts of the SEC regulations on your IT team. My name is Jennifer Kelly, and I'm with Haiku, and I'll be moderating today. Our panelists today are Alex Green. He is the Chief Information Security Officer for Delta Dental Plan Association. As the CISO at Delta Dental Plans, Alex has pioneered a comprehensive security strategy across the board, ensuring optimal security standards while delivering user needs securely. We also have Andrew Serwin. He's partner and co-chair of the Global Data Protection, Privacy, and Security Practice at DLA Piper. As a lawyer, Andrew Serwin combines the practical experience that comes from having been counsel in many of the leading privacy and cybersecurity matters with the breadth of knowledge that comes from having written the premier global treaty on privacy and cybersecurity. And we also have Eric Basu, the esteemed CEO of Haiku. Eric bootstrapped Centec Global, a leading cybersecurity defense contractor in the San Diego area, and sold it to Deloitte in 2021. As a result of that, Eric saw a tremendous need for skilled training in the cybersecurity world and has created Haiku. I'm now going to pass the mic over to each of these gentlemen to tell us a little bit about their background and welcome all of you. So I'd like to start with Alex.
Oh, thank you. And thanks for having me today. So Alex Green, CISO for Delta Dental Plans Association. Like you said, the goal here with our distributed way of business we do at Delta Dental is to really build a more comprehensive security strategy. And while we specifically are a nonprofit, it's really interesting to see the movement with the SEC guidelines and how we can adapt that to a new security standard.
Thank you. Eric?
Hi, Jennifer. Hey, everybody. So Eric Basu, I'm the founder and CEO of Haiku Inc. I formed Haiku after I sold my last company. We were a defense contractor. We hired hundreds of cybersecurity people over the years, and I kept running into the problem where I couldn't tell from their resume, their degrees, their certs, whether or not they could actually do the hands-on work. And so when I sold that company, I formed Haiku to be able to teach people actual hands-on skills using a game-based format.
Thank you. And Andy.
Hi, Andy Serwin, at DLA, partner and global co-chair of the Privacy and Cybersecurity Group, and do a lot of work with public companies now trying to comply with the SEC requirements, as well as a lot of incident response and data protection work. So thrilled to be talking to you today.
Thank you all to our panelists. We're really excited for all of you attending today. Just a little housekeeping. Everyone has been muted, but we invite you all to drop questions into the chat. We are going to leave plenty of room at the end to answer what we hope to be a lot of questions. So for today, as you know, we've already done our introductions. The next step here is that Andy's going to give us a lovely overview of the recent SEC regulations. We're going to do a quick panelist Q&A and then an audience Q&A, and then we'll be ending our meeting. Again, thank you all for joining today. We hope that this thought leadership series is something that you find compelling and that you join us each month as we explore new topics in cybersecurity. And so now I'm going to pass the mic over to Andy Serwin to give us a really comprehensive overview of the new regulations and the impacts that they have on cybersecurity globally and the business-to-business market.
Great. Well, thank you. I think the important thing to really focus on before we get into the details of this is that the SEC requirements apply to public companies predominantly in the US, where there are some exceptions with foreign filers and some other edge cases, but the purpose behind them is not to impose substantive requirements around the cybersecurity rule. It is more to ensure that the investing public has all material facts in the SEC's view. So topics for other days we won't cover today. There are state laws and there's a variety of other laws that can impose substantive burdens on officers of companies. The SEC, with the exception of the Sarbanes-Oxley Act, predominantly doesn't do that. It's much more about disclosure and making sure you have the right processes for that. So if we get to the next slide. what we're seeing is increasing enforcement with the SEC, and obviously rules are important, but the enforcement is what drives behavioral change, at least in the SEC's view. And that can be enforcement against a company, enforcement against individual officers or other individuals at a company, or both. And so when you look at what the SEC is driving at, there's really three core things that we have in addition to the 8K requirement. And maybe just to deal with the 8K requirement first, that is a requirement that certain material events be disclosed to the investing public through that particular filing. And there's a definition of what a cybersecurity incident is. Materiality we'll get to in a moment, but you have typically 4 business days from the date you determine something is material that is required to be disclosed under 8K to disclose it to the investing public. And as we all know, in a cybersecurity incident, that's not a lot of time. And you have to get to materiality determinations without undue delay is really what the SEC is expecting. And so that's piece one, which is there has to be disclosure of certain events that meet certain threshold criteria within 4 business days of the materiality determination. The other thing, and this is where there isn't a substantive requirement per se, but the mere fact you're having to disclose it probably makes you focus on it more, which is there has to be more disclosure of what your cyber risk posture is in your periodic filings. There has to be disclosures around policies and controls around cyber. And there also has to be disclosure around cyber governance at the board. And so, again, there's not a governance requirement explicit in these rules necessarily, but by having the control requirements or the disclosure requirements that do require disclosure controls and procedures, or DCPs, you effectively have to have governance, even though it's not expressly required. So it's more of an operational implication of these rules. And so what all this is driving towards, again, is in the SEC's view, clearer and more fulsome disclosure of risks, policies, controls, governance, and certain cyber events. When you summarize it, that does create the opportunity to have additional knowledge in the company. And once you've documented something, as we all know, in a lot of cases, you can't simply ignore a material issue regarding cyber. And so, again, under Delaware law, which is beyond our topic today, but there are requirements to actually remediate some of these issues at times. And so it starts creating a box for certain executives, particularly the CISOs, because they will have to go looking more than they otherwise would have before. And once you find a problem, then you're going to have to deal with it and escalate it. And so, again, that's the focus. So we can probably go to the next slide. When we get to materiality, I wish I could give you a better definition than this, but that is the definition, which is an omission or misstatement. So it can be an issue of having an incomplete disclosure or an actual affirmative misstatement that basically a reasonable person would want to know in hindsight. And that's always the issue, right? I mean, the SEC is looking at this after there's been a problem. And so what you're really saying is, would this have been viewed by the reasonable investor as having significantly altered the total mix of information? That is not a clear standard. And courts obviously can disagree, as can the SEC. And so what you end up having to do is really think through what could cause something to arise to that level. And that includes both qualitative and quantitative risks. And we'll, in the next slide, get to how we start to really define that. If we boil Delaware law down, which is relevant for many companies, publicly traded or not, given the number of companies that are headquartered in Delaware, you can really look at 4 corporate principles. There's 2 value drivers and 2 risk controls, and business strategy and financial performance are your main value drivers. Resiliency and legal compliance are your 2 risk controls. And so that begins to help us define qualitative and quantitative risk. If we go to the next slide. And here, what we're actually talking about is governance and how we would govern risk. And the point of this is to really illustrate one of the things I see frequently, which is an over focus on that orange box, which is program creation, controls, and implementation. Again, under Delaware law, really, when you boil governance down, it is setting a direction, strategy, risk, including risk tolerance, risk appetite, having oversight, having a program, and measurement and reporting. And what this slide is really supposed to represent is that the governance process is the same no matter what you do. It just, the controls that you're putting in that orange box are different, because if you're doing corporate governance, you're measuring and controlling different things. If you're doing privacy versus AI versus SEC requirements, those are all different things as well. And so while those policies, the artifacts, other things may change, the other four boxes really don't. And as we'll see, if we go to the next slide, we can then define corporate governance, which is really taking the four principles that we talked about earlier and then putting that together with the governance process. And so when we talk about corporate governance, and we'll get into how this nests with cyber now, but that's really how you have to do it. And so when you look at these situations, what you want to do is have your governance program be nested. So beneath the corporate governance model, whether you're publicly traded or not, you want the subsidiary and subordinate issues, whether that's cyber, whether that's privacy, it's AI, SEC requirements, all following the same process with different controls. And so that's where I see, in many cases, companies really begin to get begin to struggle, is they think governance is controls and they won't set direction, strategy. They won't necessarily have the right level of oversight, and they're not tying out to corporate governance principles. And that's where issues can become much more difficult to solve. One of the things that, having worked on a lot of breaches, I think one of the things that we've not done well in cyber is we think of cyber as a risk, and I believe it's actually a root cause. And by that, I mean what we've done over the last 20 plus years is really make 95+% of our business processes dependent upon the use of data and connectivity. It's hard to imagine many that matter for companies that don't rely on some version of connectivity through the internet and the free flow of data. And so what this slide really represents is that a way to think of risk as we look at the SEC requirements, which is companies make money by creating processes that produce goods and services. The risk to the company isn't cyber. The risk is the disruption of the data and connectivity that makes those processes work. Cyber or privacy or anything else is really the root cause. And it's not to say that we don't need controls in place for cyber. Cyber, the reality is it's going to be the main root cause of a disruption of data and connectivity. But the example I use is, if you have a data center and you get hit with ransomware and you're prepared for ransomware, but you're not prepared to deal with a flood or a hurricane that takes the power out to it, and you're down and you have a disruption, you have just as large a problem, whether it's caused by a malware group or a natural disaster. And that's why, again, root cause is important when you're building control frameworks and trying to really manage some of these issues. But for the board, and for the senior executives, the risk, and really the risk to the company, is the disruption of these processes because of the disruption of data and connectivity. So it's easy for the lawyer on the panel to point out a bunch of problems. Let me try to get to a place where we're talking a little bit about how to rethink some of this stuff and get to some solutions. And then I know we'll cover other topics, so we can move to the next slide. Resiliency is a hard concept at times to grasp, and what we've tried to do here is, as we pivot out of thinking of cyber as a risk, start to really talk about risks that are more concrete, and this begins to make it easier for the IT teams and the information security teams to think through, if there's a cyber issue, what are the consequences of it? And you can see here, when we talk about resiliency, it's usually interruption to the business of some kind, and there's a variety of different things. And this is an abstract view of it. These are very company specific, but a lot of these remain the same. There is obviously a financial impact. And as we then look at the right side of this slide with the legal risk, those are the more traditional risks we tend to do a little bit better job of disclosing and thinking through, which is you have a lawsuit that could cost you, $500 million. That's usually over the materiality threshold for most companies, and they're going to be somehow disclosing that, whether it's in a periodic filing, an 8K, or both. But it's much harder to quantify at times the financial cost of a slowdown in receiving goods or services, particularly in the middle of a breach, because you don't know how long it's going to go. But what the SEC is trying to do, and I'll go back to the quantitative and qualitative, you can really think of the resiliency side of this slide as being the qualitative things that the SEC is generally looking at. And the legal risk side, not perfectly, but closely, really tracks that quantitative risk that we talked about earlier. And so, again, as we're starting to rethink this and thinking through how are we going to start complying with these rules, I do think you need to have a wireframe like this for everyone involved in the disclosure process to say, okay, we get that cyber matters. We have to look at cyber. Not all cyber events are necessarily the same, and ones that have a significant impact on one of the operational resiliency components there is more likely to be material than one that doesn't. And that's how, that's not the nature of what most IT and information security people are trained on. And so that's part of the pivot point we've got here, which is how do we start getting people ready to start figuring out what escalations look like, how to start assessing, even if they're not making the final call on materiality, how do they start thinking about getting the right information to the people that have to make that call?
I was on mute. So I'll jump.
I was just going to say, I would like to hand it over to Eric now. I apologize. Go, Eric.
All good. So this is really interesting to me. I mean, we formed Haiku basically as a better way to address cybersecurity training. And I'll just go down that tangent for just a little bit and then come back to what's directly relevant to what Andy said, which is that current cybersecurity methods, whether you're learning in a university or you're going through a boot camp, or you're sending your people off to a SANS course for $8,000, none of the current cybersecurity training actually addresses this particular issue. And you have other things like cyber ranges and such that are very technical in what they teach, but they don't actually have the ability to train your IT staff as to what they need to recognize and elevate up the chain of command, so to keep the CISO and the C-levels and to possibly even the board out of hot water with the SEC. And so with Haiku, we actually created game-based trainings. We actually use games to teach people. And there are two concepts it's based on. One is that a good game gets your brain in the flow state within 15 minutes. And the other is that when your brain's in the flow state, based on a study by McKinsey, you're 500% more likely to learn. So that's the efficacy of the training. We also have a tool called the Forge tool that allows any organization to be able to drag and drop and create their own training. So in a situation like this, let's just take an example of a manufacturing company. And in this case, they have a third-party supplier that suffers a breach that doesn't impact the networks of the company. So in the company, the line managers, including the network and the IT staff, and maybe the cybersecurity staff, if they have them, they don't think it's important because it doesn't impact their network. So they do report to the CISO, which is important because the CISO has been notified, but it's buried somewhere in the weekly report. It's not, listed as a high risk sort of thing. Now, let's say that supplier was doing a small amount of money, let's say $1 million a year in supplies, but that particular part was critical for the manufacturing, and that shuts down the manufacturer's production line, costs them many millions of dollars. Now the SEC is ticked, and so the SEC investigates the manufacturer for failure to notify the SEC. And the question is, how could this have been prevented? You're not going to prevent this by sending your IT staff off to a SANS course. You're not going to prevent this by giving them, a cyber lab training, because none of those things actually address this. And so, but if you have the ability to customize training for the manufacturer, and you actually train them on very specific examples, so you give this a very specific example, and you show them in the game-based training, this is the kind of thing you need to report, and distinguish it, of course, from things they don't need to report. They don't need to report on a user who forgets their password or something else that's not material. But right now that training doesn't exist, but the training needs to exist with these new SEC rules that I think came in place just a couple months ago to keep the company itself out of hot water with the SEC. And so that's one of the things that you can use Haiku's Forge tool to do. And I'm happy to, if anybody's interested in how that would work, I'm happy to talk to you about it. We're actually releasing a product before the end of the year that specifically addresses this issue, which is how do I train my IT staff on how to recognize what requires SEC reporting. Next slide, please.
Great, and now we're going to move on to our panel discussion. Our panelists know that what we're going to ask for them to do is have a great lively discussion amongst the three of you on the topics that Eric and Andy just presented. Next slide, please. So the first question we have is, what do IT professionals need to do to comply? What experience is required for IT professionals to report to the C-suite executives? And on this one, I think I'm going to start with Andy. You're muted, Andy.
Sorry about that. I think you've got to start thinking beyond just what is material in a cyber sense. And there could be some material issue in the company that doesn't give rise to a material consequence that the SEC would care about. That might, in the end, have to be disclosed in a risk factor, but for an 8K, maybe not. And so you have to start thinking, we have to start using the same terms. And I think that's kind of where part of this has to go is the board and the senior leadership are using certain words in one sense, we're using them in a different sense in the subject matter areas. And so the experience of really understanding what needs to be disclosed, what these requirements are, what the language is around it, and what the disclosure committee would actually look at and how that process is just not something that IT professionals really get because they haven't had to before now. And so then for the C-suite, it's almost the flip. It's not that they need to become subject matter experts in the very technical side of this, but they need to start thinking about cyber less as a technical issue and more as a qualitative and quantitative risk to their business. And, again, I think you can have the discussion of cyber impact without getting into, what your EDR is or what your containment strategy is. You can explain to a business executive, these business processes rely upon these, the use of data or the use of technology. And if we lose that, here's the business impact. That's why, this event matters and this one doesn't. So I think it's moving into that direction that we're all going to have to go there.
Alex, Eric, sorry to go back to that. What kind of experience do you guys think is going to be required? Andy as well.
You want to go, Alex?
Sure. Yeah. I mean, I was going to answer the question directly with understanding process. I mean, exactly to Andy's point, the materiality conversation isn't unique to cyber. It's just now cyber is becoming part of that stool. So what does it mean for incident response to lead into a materiality conversation, and what information do you need to collect at the cyber level to help justify that decision within the 4-day margin now? So, I mean, education-wise, it comes down to how does your governance, risk, and compliance program function? How does the incident response process really work up through all those interconnected pieces?
You wanted to respond to this with a question, maybe to Andy and Alex. In an organization, who is the best person to lead the definition process? Does that person come from operations, or do they come from IT, or do they come from somewhere else?
So I think for this, the definition, so that you actually need probably two definitions at minimum. You need an intake definition, and then you have the SEC definition, right? Which we all know how clear that is or isn't is a different thing. And so I think definitionally, it's got to make sense to all of the stakeholders, but it's in all likelihood, it probably is the lawyer's driving that in certain ways, but driving it in a way where everyone's sort of on board with it. But you do have to create this funnel, because if you define an incident the way we normally do in IT, that is not how the SEC has defined it. And even if it was, what I know is if you have sort of your starting definition is your ending definition, you increase the risk that you're going to miss things. So you need some level of margin of error in all likelihood around that initial definition to make sure, unless you can assume perfect performance by your team, you probably need a little wiggle room, right? And so you've got to broaden the SEC definition, and that's where it's important to have stakeholder input. But ultimately, these are legal consequences with the SEC, and I think not to be the lawyer, but the lawyers probably have to have more of a sway in that than in other areas.
Yeah, that makes perfect sense to me.
Next slide. How should privately held companies change in anticipation of future laws that could apply to their organizations? Alex, I'm going to start with you on this one.
Yeah, I think I'll answer again with a bit of process. That's going to be the biggest piece in my mind, understanding really what, you should already have defined to a degree what level of artifacts and information you should collect when performing incident response. But now that's going to start mattering more to the edge of materiality is what did you do your due diligence? Are you, I'll risk using the phrase checking the box, but are you actually collecting all the information that you can legally defend? I think that just is going to have to be kept in mind as this expectation hits public companies. It's, in my mind, a good model for the private companies to adopt.
Andy, do you have any suggestions on how you would counsel a private company to think about upcoming changes based on what's going on with SEC?
Yeah, look, for a private company that isn't subject to it yet, if they're looking down the road as, filing an S1 and going public, you would want to make sure you have the sort of backbone or pieces you need ready when you're going to have to do those initial disclosures when you go public, and then the periodic filings, then be ready for the 8Ks. So it's, some companies will go to the end of saying, we're going to pretend like we're, public and build compliance and governance around it. To me, ultimately, it's a governance issue. You have to have the governance around this and the right people making the right decisions overall. And Jennifer, it's okay. I'll pick up. I see one question in the chat. I may pick that one up. The definition of material is what I had put up before. So it's that ambiguous, and it gets usually litigated. So it's not that it's the courts tend to define it, but it is a very squishy standard. The organizational definitions on materiality, you really can't change. You can, and you can't change the other definitions, at least in terms of legal consequence. You can broaden them for your own internal purposes and say, we're going to go beyond that to get things in the funnel, and then effectively figure out whether it's material or not. But those definitions are the definitions that you have to be true to ultimately, or the SEC can come in and enforce. And if you're too narrow, obviously you can miss things, and then that's when you get into enforcement trouble with the SEC.
So 10 seconds to respond. What's your favorite publication to reference for up-to-date industry info? So go ahead and drop your responses in the chat. And while we're doing that, I'm going to ask Leslie to go ahead and progress. Thanks. So let's continue with our questioning, and again, feel free to ask each other follow-up questions as you like, panelists. Would you consider the CISO role to be a personal risk now? Why or why not? And I'm going to start with Alex now.
I think it's definitely heading more in that direction. We see things like the Wells notice to the SolarWinds CISO. We see some of the stuff happening with the Uber CISO with withheld information there. It's I think the personal decisions that are made in these processes are now becoming more of a personal risk.
Eric, Andy, anything that you guys want to add to that?
Look, the scrutiny is pretty high, and I think that's part of the reason I think it's in, everyone's interest, certainly the CISOs, to have the right escalation, because ultimately the CISO's probably not the one making the disclosure call, right? And so that's really the key is, and there's a lot of great CISOs out there. At times you will see a mentality of wanting to keep kind of the information security function a little shielded from the business. If I were a CISO, that is the last thing I'd be doing, certainly before, but absolutely now, because the reality is these decisions, like it or not, these definitions, like it or not, are driven by lawyers. And I wouldn't, as a CISO, want to be making calls about what is or is not material, or what is we should or should not be disclosed, because you put yourself on an island, and then ultimately, if stuff goes wrong and it was the wrong call, you're the one that the SEC is going to look at, right? And so this really has to become escalated even higher in the organization, so that the facts are disclosed where it's appropriate. Obviously, the CISO should have, input into it, but usually these disclosure committees aren't relying on a single subject matter expert to make the call. And so I think it's really you have to start changing your mentality as a CISO if you're someone who's tended to think, I am the subject matter expert here, I've got this, I'm the one making the risk calls. You can do that now, but you better be ready to take the full consequences of that risk call if other management and executives don't understand it.
That was well said. Good point.
I'll go with this one because it's a great lawyer answer. It depends, because look, and we kind of talked through this just there, right? If all the information that's relevant is escalated to the disclosure committee, that's different than if the CISO has a bunch of information that the SEC in hindsight feels was material to the decision that wasn't disclosed, right? And so typically the board in most public companies should be engaging in oversight, not operations, right? So they may be aware, they may have sort of some role in I won't say approving, but having input into some of these decisions, but ultimately it's management, and usually the senior management of a public company, that's making the decisions. The CISO certainly may be part of that, but shouldn't probably be, again, exclusively that person. There obviously are civil penalties. There can be criminal charges with some of this stuff. One thing we haven't talked a ton about is there's all these rules, but there's also the insider trading issues, which is if you're trading in securities and you're deemed to have material non-public information, that can turn into a different SEC problem pretty quickly, right? And so if you're at a public company, again, to go back to my, the Lone Ranger CISO, not where I'd want to be if of 10 incidents that no one else knows about that the SEC suddenly determines were material and you're trading in securities. That's certainly not the position I'd want to be, whether it, you beat the case or not. You don't want to have to go through that. And so clear disclosure, not over disclosure, but certainly not under disclosure, is really, I think, where this needs to go. And that puts everyone in the best legal position.
I have a quick question, Andy and Alex. How different is it now with the change in the SEC laws that just came out? I mean, how much more liability is there? Is it 25% more, 5 times as much? What's the difference between what it was before and what it is now?
I'll start. So I think the difference is a lot of companies had been disclosing. What's different now is there always were requirements around disclosures regarding risks and certain material events. What the SEC has done now is make explicit exactly what it expects in the cyber area. And so it is much, I would say, easier for them to start bringing enforcement, because previously they were relying on saying sort of, well, cyber's material to your company and therefore you should have done X. Now they're simply saying, we told you to do X, you didn't do X, right? And that gets into a lot of these things of how do you implement this. Not having a policy is, one of their easier cases, right? If you don't have the policies in place to do what they say, it's very easy for the SEC now to come in and say, we said X, you needed to do these 10 things to do X, you didn't do them. That's easier than saying, well, we think this was material, and had you disclosed this, the investing public would have, handled this differently. So it's I don't know if the total liability is higher. It probably is, but it's a much easier track for them to just go right at people going, we said X, you did Y, therefore we're bringing an enforcement action.
Yeah, I think it helps the prescriptiveness of it all, honestly. I mean, towards that, what do you need in place? It helps you justify some of the actions you take in your security program, at least it should, and ultimately how you quantify and present risks. So, I mean, there's going to be more onus on the GRC side of the house to kind of button everything up, but I think it helps the process.
So I'm going to ask our panelists to respond. What's your biggest pet peeve for human behavior and security awareness?
I'll start. I think it's the uncontrollable human desire to stick a strange USB into their work computer. When they do these tests, 70% of people, if you just drop a USB into somebody's parking lot that says, sensitive pictures, 70% of people will stick it in their computer.
Alex?
Yeah, the physical is a good one. I would have to say reading comprehension. When an error pops up, what is it actually telling you? So, I mean, people tend to clear out that window as quickly as possible, whether it's click the yes or ignore it. That'd be mine.
And I would say our almost insatiable desire to go outside policy and create shadow IT by putting software on our boxes we shouldn't put.
Good. And I'm going to say clicking on emails that are obviously phishing. That was my pet peeve. Okay, back to our question. So how will this impact the 2024 budgets differently? How much of a department's budget should be allocated to mitigating or responding to SEC questions? And I'm going to kind of take it from a training perspective. How much budget now are you going to look to allocate to train your employees to not raise a million red flags in fear of some sort of SEC or, violation? And I'm going to go ahead and pass that on to Alex to start.
Yeah, definitely more than I have been. I mean, I'll jump on GRC again in the sense of that's where we're definitely going to see an increase in budget to kind of make sure everything's in line. I got lucky and inherited a rather mature GRC program as it is, but it's still going to take additional steps to align to this mindset. But for training, definitely more. I mean, we talk about tabletops and other exercises, and traditionally those don't include the communication paths all the way through legal, marketing, and what you're actually going to encounter in a full-fledged material event. So yeah, quite a bit more.
Yeah, and look, building on that, I think where you're going is your budget's inherently going to have to go up, because typically, again, I think most programs are geared towards compliance. And now you're really looking at, what do you need for escalation? What do you need for disclosure in addition to the compliance piece, right? And the escalation piece and the disclosure piece are going to require, compliance-like activities, but they're also going to require training and a variety of other things. And so, you can't walk away from compliance, but if all you do is compliance with requirements, you're probably going to struggle to meet these new requirements from the SEC.
Thank you. So is the board going to pay more attention to the flags that they're alerted to? And do you think that it will change which ones worry them most, or they just sort of escalate the ones that they typically worried about most? Andy, I'll start.
I think they're going to have to. Yeah. I mean, look, I think the net of this is there's going to be much more disclosure up the chain of, material cybersecurity risks and events. And then again, if we go into the sort of Delaware side of this, if those are mission critical red flags, the board isn't the one fixing those, but they've got to oversee and have a program to oversee, make sure they have the right information systems, and not consciously disregard red flags that they're aware of. And so, if you're one can have a debate of whether a mission critical red flag is the same as a material, cybersecurity issue when it's a cyber issue. Not for today, but say they're close enough that it's going to cause a lot of, I think, boards that are subject to Delaware law or similar requirements under Caremark and other cases to say, okay, we've got to, as part of our oversight duty, we have to, be aware of this, but also make sure that management is doing the right things to, have the right resources to fix these things, but also no one has unlimited resources. Prioritize their spend in a way that, tries to get the risk to be a rational place for the company.
Yeah, and I kind of want to ask a follow-up question to that. So how do companies start to calculate the financial risk associated with this? Does it change that, or was it already there and they just didn't pay or didn't have anything looming to make it more of a concern?
I think it may even be a little different. Most public companies will have a materiality threshold for the quantitative, right? And I think what's really happened with cyber is there wasn't always a full understanding of the qualitative risks that we have in cyber, and so this rule sort of shines a light on, okay, you've got to start disclosing those, and as a result, where you have risks that haven't become an event yet, that's where I think companies are going to have to decide how much can they invest, how much should they invest to deal with these sort of, I won't say hypothetical, but unrealized qualitative risks where it's hard to put a dollar number on it necessarily, but there's a significant impact to the company. I think that's really where companies struggle and are going to continue to struggle to some degree.
And one more question. Oh, sorry, Alex, go ahead.
Oh, to add to that's actually a path we've been going down, is adopting more the FAIR model for kind of individual financial impact of each risk. So, I mean, the quick answer to that first sentence is yes, but it's also up to CISOs to, and this is where we've traditionally struggled, is how do we actually present these risks to the board in a way that makes sense that they can understand?
And that's why I go back to, as weird as it is for someone who does a lot of cyber to say it, cyber is a root cause, it's not the risk. Boards struggle to understand cyber because it's so theoretical to them. You tell them you're going to lose a business process that is responsible for $2 billion in revenue, that they get, right? And that's really what we're saying with cyber. And I think that's part of the language change that honestly the CISOs and the privacy people with data have to do the same thing. We just have to start talking in terms the board understands.
Agreed.
And so is that, Eric, I'm going to throw this out to you. That's kind of, I think, where we're headed as a company, right? That this training, everyone needs to be cyber literate. Everyone has to have cybersecurity skills. So we're going to see that, like, Andy, as you said, there's a little bit of this mystery around, like, what do these IT people do? And they're raising red flags where they understood the business process really clearly. So Eric, I'm going to let you kind of weigh in on that.
Yeah, there's two sides of that. Certainly you want to, with your corporate cybersecurity awareness training, you want to make sure that your people are understanding of some of the overall risks. But a lot of this is the reality is you're never going to get your board members to understand, the technicality of ransomware, right? I mean, like if you look at the MGM hack that just happened in my hometown in Las Vegas, it's not necessarily important that the board know which malware caused it, right? What's really important is that from a reporting standpoint, the people who are getting exposed to that, which a lot of the time are the regular line IT people, not even necessarily cybersecurity people, they know what to elevate up so that the C-levels in the board, the executive team of the board, know what needs to be reported, because that's far easier to do, to be quite frank, to be able to train the line staff on, this doesn't need to be reported. Let's just say it's a user password reset to take something very easy, and this one absolutely does need to be reported. And you can train them over that. I mean, that's that's what where I was talking about with Forge and Haiku, and that you can create different scenarios for people and run them through that, and then people can understand that. But you're never going to get the board members to go through any kind of training that tells them the different kind of malware, nor is that particularly useful, really. And also, I mean, there's only so many board members, but you have hundreds or thousands of line managers, you need their eyes and ears, and you need their awareness to be around what needs to be escalated. That's the only way you're going to be able to get all this.
10 seconds to respond, panelists. What is your most used non-work related app on your phone, and how many hours a day are you on that app?
Reddit by far.
I was going with that, but it's Signal for me then behind it, and a lot.
Yeah, can I plead the fifth on hours?
Those are both kind of work apps. So I use Duolingo. So I'm not on there for hours. I don't actually have hours of free time per day, but I do juggle between like 5 different useless languages. So it's a good way to give my mind a break.
Great. So how does training impact the SEC regulations, and how should an organization train their current workforce in response to these new regulations?
Why don't I kick that one off? Look, there's not a specific training requirement under the SEC rules, right? But I think we all recognize that in order to implement this, people are going to have to learn new things, and we have people in technical roles who have to start understanding in a much broader way some of these governance issues, some of the issues related to what the standards are for the SEC, even at a line level almost, where they have a role that's important to escalation. Obviously, the CISO is going to have to start really understanding the implications and consequences much more. But I think there's that, and then I do think risk is really contextual to me. It's easy to go into a board and scare them and say, here's all these threat actors, as we've talked about, but getting the board to understand the context of the risk is, I think, also how you have to do this. And I think in terms of current workforce, you may end up having to hire people in IT or IS that have the job of simply, depending on the volume of incidents, their job is to do incident review, incident triage for stuff that you might not have otherwise done. If you have a significant volume, if you don't, then you're training the people that are already there. I do think you're also going to have to start thinking about amending your incident response plans, because that's usually the basis of the escalations here. And so you may end up having 2 or 3 different definitions floating in there, which drives the lawyers nuts. But IT may want one for their purposes, but then we need a different definition, and then everyone's going to have to be trained on that when we need the definition for SEC purposes. So I think it's going to be complicated and hard to work through for the next several months as we do this.
Yeah, just to add to that, I think Eric's spot on in terms of how we need to help provide an environment where the line managers and the analysts can understand what makes sense to escalate and how and why, and understanding kind of what that turns into on the legal side of the equation with materiality determinations and public filings. That's definitely missing in today's training.
Yeah, and I'll just add on to that, not to beat a dead horse, but I mean, that's one of the best uses of our Forge tool, is the ability for companies to customize, because companies are going to have different escalation, right? I gave the example of a manufacturing company, but a financial company is going to have a different set of things that they want to train their staff on, an e-commerce company. And so the ability to have customized training so that you can also assess the level of or train to the level that you want your IT staff to be reporting on, right? You can say, hey, I want to be extremely conservative, and I want them to report on everything that is even could remotely possibly be elevated, and then we'll filter through that at a higher level. Or you could say, I want them to be relatively that they're not trying to pick up too many false positives, too many risks, and so I want them to make the decision at their level. And I think that really is something that each company kind of has to figure out on their own. I mean, as Andy alluded to, the definition of materiality by the SEC is extremely loose, extremely vague. So a company really has to decide. Every company has their own risk tolerance in a number of different areas. They actually have to decide that and set their training based on that.
Excellent. So that ends our Q&A for the panelists. And I would like to open it up to the audience for some chats. And we'll give people a second to throw some questions in there. But I did have another question that came in, which was, is there any recommendations on how often you should be running training exercises? Or thoughts on that?
I can jump in. From my perspective, I mean, there's going to be a few pieces there. One, obviously annually at a minimum, new employee training, but the cadence in between. Curious to Eric and Andy's thoughts on that, but I would think at least quarterly. I mean, thinking back to how we traditionally approach developer security training, quarterly seems to be the most effective from my standpoint.
Just a thought on that. I know that when my last company was a military contractor, and the big buzzword was continuous monitoring for IT. And we've started using the term continuous training because you got the, semi-annual security awareness training that, appears to be more painful than going to the dentist for people because they just refuse to do it. And it's also the problem is it's very ineffective, right? People don't want to do it. And that's one of the things we're trying to do with game-based training is actually create games that are interesting enough. They're actually fun to do that people want to do them on a continuous basis. And then, so if you have continuous training from a CISO's perspective or a CEO's perspective, you can just look at the level of training and you can see who hasn't done it in a while, and you can ask them to, jump in and participate in this ongoing series of games that are going on with the company. I personally think from a perspective of trying to actually mitigate risk, it's a lot better to have people kind of thinking about it at some level all the time, rather than just, I'm going to put my mind into the point, the framework where I'm going to go through this darn video or this darn PowerPoint every 6 months, and then I'm going to forget about it and never think about it again.
Yeah, the only thing I'd add is, look, from the sort of lawyer perspective, you've got to look at it through the lens of, you've already had a problem if you're asking me how much training you should have done at that point. And so it's, what can we put in front of the SEC or other regulators to say we did what was reasonable, right? And that's not, there's not a clear once a quarter or once a year answer, but it's going to vary by risk profile. It's going to vary by the type of people you're training. If you have a sophisticated workforce that understands these issues, that maybe that's different. But I'm sure the SEC has thinks it's more than I think it is. So that's what you have to factor in.
Absolutely. And I'm sure that, if you have the ability to prove that you have provided this training that limits the risk, right? That's part of.
It helps tell, it helps you tell, create a narrative in a good way, right? Which is, we didn't just have a piece of paper. We actually tried to do things to get people to not only comply, but actually understand what they should be doing.
And Alex, I had one more question that came in, and someone said, and I'm going to throw this to you. Do your employees really like training?
No, exactly to that point. I mean, the traditional approach, we try and make it as fun as we can, but no, everyone's going to click through it as fast as they can to get rid of their compliance requirement.
I mean, just to add on to that, I mean, it seems like every panel I give, I have at least one CISO, if not like 3 to 4 CISOs that come up to me and go, I love what you're doing with the games for cybersecurity upskilling training. Can you please do the same thing for cybersecurity awareness training? Because my employees hate it. The worst situation I've seen, just to give a quick anecdote, is a government entity that they're training, they actually have a training module they paid big bucks for, but nobody does it at all. So what they do is they hold quarterly training where, as an all hands, where they force everybody into a room, they show a terrible PowerPoint. And then when they complete that PowerPoint, they check off the names and they go into the system and manually say that they did the other training that they paid for, but they never did. And so that's the way they hit the compliance. I mean, it's satire almost. There has to be a better way to do the security awareness training. And we're working on it, by the way.
Excellent. Well, I wanted to thank all of our panelists. I think this was a great discussion. I'm sure that all of our audience has really enjoyed listening to how we perceive the impacts of the new SEC regulations. I think you guys did a great job. Thank you for that. So I wanted to let everyone know that we have a monthly thought leadership series. And so the next webinar will be on fostering cybersecurity diversity and leadership. And it's October 18th at 12 p.m. Eastern time. And we will be sending out invites to all of the people in attendance here and looking forward to that as well. And one last note, if you'd like to get a hold of any of our panelists, their contact information is below. If you'd like to get in touch with Haiku, our information is right there. We're happy to talk to you about how we're providing the type of training. I like to think Alex and others might wish their employees were stop training and get back to work because it's so engaging. And we welcome you to reach out to us to learn about our assessment and training for the corporate market. And thank you again today. I appreciate all of your time, and I think the panelists did a great job, and we appreciate your attendance today, and have a great day.
Thanks, Jennifer. Thanks to the other panelists.
Thank you.
Thank you.